Our next speaker, really our first speaker for the day, is Les Malezer, and he's going to speak about the Indigenous issues on the international and the domestic stage. Les is co-chair-elect of the National Congress of Australia's First Peoples. He is from the Bachala Gubbi Gubbi peoples in southeast Queensland. He has extensive experience in campaigning for Aboriginal and Torres Strait Islander rights, having represented community interests at local, state, national and international levels. He's a former head of the Queensland Department of Aboriginal and Islander Affairs. He's currently chairperson of the Foundation for Aboriginal and Islander Research Action. He played a major role in coordinating Indigenous peoples' advocacy for the adoption of the UN Declaration of the Rights of Indigenous Peoples by the UN General Assembly, and in 2008 he won the Australian Human Rights Award. Please welcome Les Malezer.
Thank you very much. I'm finding I've got to do a lot of this walking up to the podiums nowadays. I have to get used to an entrance and how to do this. All very new for me. I'd like to start off by acknowledging the Aboriginal people, the owners of the land in Australia, the First Peoples of Australia, and particularly the people of this region, the traditional owners in this area, and thank very much, of course, Marucci for her welcome for us to meet here and talk about these issues today. Also acknowledge the distinguished guests and speakers that are here at this conference, including Claire and Mary and Salil, but I know there's many others that will appear during the day, and people I know in the audience as well for being here, and of course acknowledge and thank you all for attending this conference and its purposes. I'd also like to go on to just talk a little bit about Amnesty International, that I have had a long association from the 1980s, when I was working on matters like the Aboriginal deaths in custody. I was dealing with Amnesty International, particularly with the head office in London at the time, who did a lot to campaign at the international level about our rights here in Australia. And more recently, I became a member of Amnesty International, and I've worked with the local chapter here, the Queensland and Northern New South Wales branches on Aboriginal and Torres Strait Islander issues, and also at the national level. I'm very, very pleased to see that Amnesty International has employed Aboriginal people now within the organisation in Australia, and also there's a representative on Indigenous peoples working at the headquarters in London as well. So it's great to see this growing understanding, linking and bonding that's happening between Amnesty International and Indigenous peoples. And I suppose I should add there that during those critical months when we were lobbying in New York for the adoption of the declaration, the representative there from Amnesty International was a large part of the lobbying exercise, particularly as that person had the experience of being able to go onto the floor in the United Nations meetings and talk to states. They knew him and he knew them, and they had a big part to play in the success of the declaration. I worked on a presentation, as you see up there, talking about the international and domestic stage, but really I'm going to give you a strong picture at the global level of what's going on about Indigenous peoples and rights. And later today there will be a panel session which talks about actions, things to be done, and what are the issues and so on. So I've decided that I would, having to cut down the size of my speech, that I would concentrate very much on this bigger picture, which is really getting across the message that Indigenous peoples have organised at the global level and are operating at the global level and have been very successful at the global level, and that change is happening. In Australia, it needs to happen. We're seeing some signs. The interest of the government in looking at the Constitution for recognition of First Peoples is a sign of that change, but of course we've still got a long way to go, and perhaps I will finish up in my presentation of just talking a little bit about where we are in Australia and how things should progress. So the Declaration on the Rights of Indigenous Peoples is a significant benchmark in human rights history. It's an instrument pursued and achieved by Indigenous peoples out of necessity. In the modern era, Indigenous peoples have vigorously sought status in the international community to address the colonisation and exploitation of communities, territories and resources. As far back as in 1923, the Haudenosaunee chief, Descaher, travelled to Geneva to address the League of Nations as a peer and to affirm and defend the right of his people to live under their own laws on their own land and in accordance with their own values and beliefs. Although the League of Nations denied this request, he did attract attention to the cause of Indigenous peoples. But he was the first in a continuous line of Indigenous delegations to campaign in global forums for the equality and freedoms of Indigenous peoples, including here in Australia in the 1930s. We saw petitions being raised and sent through the Australian government to the League of Nations for rights to be recognised. The Declaration on the Rights of Indigenous Peoples has been a long time in coming, at the tail end of human rights standard setting. It will be one of the last significant standards in human rights to be established by the United Nations, 60 years after the Universal Declaration on Human Rights was elaborated. The interpretation of rights in any one article in the Declaration depends very much upon understanding and respecting the entire Declaration as a summation document. For example, Articles 43 and 45 of the Declaration affirm that the rights contained in the Declaration, and I quote, constitute the minimum standards for the survival, dignity and well-being of the Indigenous peoples, end quote. And that, quoting again, nothing in this declaration may be construed as diminishing or extinguishing the rights Indigenous peoples have now or may acquire in the future, end quote. Despite the importance of this document to international human rights law, the Declaration on the Rights of Indigenous Peoples does not create any new human rights. The rights contained in the Declaration already exist. But what the Declaration really does accomplish is to identify rights that are particularly important to Indigenous peoples, rights that are historically and currently being denied to Indigenous peoples, and rights and freedoms which are generally taken for granted by other peoples of the world. As the Declaration elaborates rights of Indigenous peoples that have been denied, particularly rights to property and development, it exposes and addresses the potential conflicts between Indigenous peoples and those parties or bodies who have pursued their interests in Indigenous peoples' territories without regard for the rights of those Indigenous peoples. The Declaration contains text identifying the rights of Indigenous peoples to obtain remedy, restitution and compensation, and has precise language requiring fair and independent adjudication or arbitration where such conflicts exist. The Declaration contains references to states or governments and states' responsibilities that would normally be contained in a binding legal document of a human rights treaty. The first preambular paragraph of the Declaration has a direct reference to the, quote, good faith in the fulfilment of the obligations assumed by states in accordance with the Charter of the United Nations, end quote. So it's basically saying that in states forming the United Nations, and I think there's now 193 states that make up the United Nations, there are obligations in just being members of the United Nations under that charter that they have to observe. The Declaration, as a human rights standard, has the substance of a treaty. There are 5 references to states in the preambular paragraphs, and 26 of the 46 articles identify actions and responsibilities for states. This approach is unusual in a declaration or a human rights standard, but it's not so unusual if it's understood and appreciated that the achievements of the Declaration is to generate better awareness and appreciation of the rights already embodied in the International Bill of Rights and international human rights law. But those rights it brings attention to those rights as they apply to Indigenous peoples. The text of the Declaration was given the green light after 9 months of intense campaigning at United Nations headquarters in New York, and the Declaration on the Rights of Indigenous Peoples, after 25 years in drafting stages, was finally adopted by the General Assembly on the 13th of September 2007, and the final vote of 144 votes in favour and 4 votes against represented an outstanding, overwhelming level of support for the Declaration. And I should add here that the 4 votes against came from Canada, Australia, New Zealand and US. All 4 of those countries have now changed their position, and so there's a common understanding that the Declaration now has consensus support around the world. The Indigenous peoples have succeeded in the long-term struggle to set in place a substantial human rights standard addressing rights of Indigenous peoples. Fortunately, the United Nations as an entity, an international governmental body, has clearly demonstrated the willingness to uphold the interests of Indigenous peoples. And this is an interesting phenomenon given that it is states who make up the entire membership of the United Nations. It demonstrates that states are collectively aware of the global situation of Indigenous peoples, even to the extent that they are informed about the specifics of those situations, but they are reluctant to examine and rectify these situations in their own countries. This reluctance has been identified and examined by the UN Special Rapporteur on the Rights of Indigenous Peoples in his report of 2006, where he identifies that there's an implementation gap in states' actions, emerging from a lack of political will to address Indigenous issues. So around the world they found that states were willing to put in place programs, actions, legislation, but failed to follow through on that. And I think if we looked at the Australian situation, we can cite example after example of the failure of that follow through. The main problem, however, is the implementation gap, that is the vacuum between existing legislation and the administrative, legal and political practice. This divide between form and substance constitutes a violation of the human rights of Indigenous peoples. To close the gap and narrow the divide is a challenge that must be addressed through a program of action for the human rights of Indigenous peoples in the future. Since the Working Group on Indigenous Populations was established in 1982 in the United Nations, the UN has been inundated with expert reports and human rights findings that elaborate the continuing abuses against Indigenous peoples. The human rights treaty bodies have also responded by recording conclusions and recommendations, both in relation to individual states and in the form of general comments, which highlight the situation of Indigenous peoples around the world and expose the extent of discrimination that occurs by states. The United Nations has responded to civil society and Indigenous peoples' concerns by developing a number of mechanisms at the international level. These include the Working Group on Indigenous Populations, established in 1982, the International Year of the World's Indigenous Peoples in 1993, International Decade of the World's Indigenous Peoples from 1995 to 2004, the creation of the Special Rapporteur on the Rights of Indigenous Peoples in 2002, the creation of the Permanent Forum on Indigenous Issues in 2002, the establishment of the second International Decade of the World's Indigenous Peoples from 2005 to 2014, the Declaration on the Rights of Indigenous Peoples in 2007, and the establishment of the Expert Mechanism on the Rights of Indigenous Peoples in 2008. In addition to these many mechanisms described, there are also the arrangements to have Indigenous peoples included on the agendas of meetings of most of the relevant bodies in the UN, and the accreditations have been arranged to allow Indigenous peoples delegations to participate in many United Nations forums. Indigenous individuals are now being appointed as experts into the United Nations on the Permanent Forum on Indigenous Issues, and Megan Davis is an Aboriginal person at the University of New South Wales who's recently appointed to that Permanent Forum, and also on the Expert Mechanism on the Rights of Indigenous Peoples, and now even to the position of Special Rapporteur on Indigenous Peoples. It is difficult to imagine that the United Nations could establish any more structuring to address the rights of Indigenous peoples. Yet the situation of Indigenous communities around the world remain largely unchanged. The Declaration has 46 articles, but when reading the Declaration, we should not overlook the importance of the 24 paragraphs that appear in the preamble, as many of these preambular paragraphs also affirm existing rights that Indigenous peoples hold. And as has already been mentioned, the Declaration is a carefully constructed instrument over a 25-year period intended to address specifically those rights which have been historically denied and that are taken for granted by other peoples of the world. The Declaration is also a collection of component rights that should be considered in relation to each other and the overall context of the Declaration. So it should also be seen as a package and in relationship. But the Declaration does have a few key elements or principles upon which the whole document is founded. The rights as peoples. The Indigenous peoples are now accepted as being peoples in the meaning of international human rights law. The Declaration affirms that Indigenous peoples, there's a quote here, Indigenous peoples are equal to all other peoples, end quote, which appears in preambular paragraph 2. And, quote, Indigenous peoples and individuals are free and equal to all other peoples and individuals and have the right to be free from any kind of discrimination in the exercise of their rights, in particular that based upon their Indigenous origin or identity, end quote. That's Article 2 in the Declaration. These statements are central to the Declaration, as much of the Declaration is focused upon collective rights of peoples. It is a collective rights that are mostly taken for granted by many of peoples around the world, but denied to the Indigenous peoples in particular. This can refer to the right to an identity, the right to a culture, the right to a system of beliefs and values, the right to a society, the rights to forms of governance, the rights to social institutions, and the rights to territory. Without such collective rights, Indigenous peoples are prone to assimilation policies of states that assume that Indigenous peoples will adapt to formal equality and sameness. Article 3 of the Declaration states Indigenous peoples have the right to self-determination, and by virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. This text is almost completely identical to the text contained in Article 1 of the Covenant on Civil and Political Rights, which has been signed by Australia, and Article 1 of the Covenant on Economic, Social and Cultural Rights, which has also been signed by Australia, although the covenants do carry additional text in their article, namely, and I quote, "All peoples may, for their own ends, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international context." I'll finish the quote there. It goes on to say, "In no case may a people be deprived of its own means of subsistence." Some states argue that Indigenous peoples have a form of self-determination which is internal or subject to national law, but there is no agreement on this interpretation. As Indigenous peoples point out, the Declaration only affirms that the same right of self-determination that exists under international law. Article 4 of the Declaration asserts Indigenous peoples have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions. Articles 18 and 19 of the Declaration refer to collective rights in decision-making. The right to self-determination includes a right to economic development and the utilisation of natural wealth and resources. This right is elaborated in Article 26 of the Declaration, which states Indigenous peoples have the right to own, use, develop and control the lands, territories and resources that they possess by reason of traditional ownership. Another relevant right belonging to Indigenous peoples as a collective is the right to Indigenous institutions, as is covered in Article 34. There's also the Declaration, attention to the rights of redress, restitution and compensation. It says that Indigenous peoples are known to be at significant disadvantage brought about by invasion of their territories, exploitation of their natural resources, social segregation and political isolation. The protection of their human rights simply by ending acts of discrimination and of promoting their cultural identity would not be sufficient to overcome the disadvantages and marginalisation. Indigenous peoples cannot enjoy and exercise their rights and freedoms without compensation, without redress and without restitution. This applies to territories, natural resources and the means for economic development. Compensation is needed for past injustices to address concerns of poverty, lack of education, lack of skills training and the need for infrastructure. Articles 8, 10, 11, 20, 28 and 32 each identify rights to redress, restitution and compensation. The Declaration also contains in Article 40 a very important provision for adjudication of disputes that arise between states and the Indigenous peoples. This article states that Indigenous peoples have the right to access to and prompt decision through just and fair procedures for the resolution of conflicts and disputes with states or other parties. The rights of Indigenous peoples cannot be implemented without these important provisions. It is important that Indigenous peoples search for ways to achieve independent adjudication on their disputes with states. So what are the obligations arising from the Declaration? The task ahead, now the Declaration is adopted, is to develop actions and strategies to promote the Declaration and ensure that positive changes arise out of the implementation of the rights. As has already been indicated, much has happened in the United Nations during the past years to empower Indigenous peoples at the international level. There have been many structures and mechanisms developed, and Indigenous experts are now in the UN system. The Permanent Forum on Indigenous Issues is now able to advise the Economic and Social Council on a broad range of issues under its mandate and has the advantage of an independent secretariat. The Permanent Forum is able to coordinate with the many UN bodies and agencies to ensure that Indigenous issues are receiving close and specialised attention. The Human Rights Council has established the expert mechanism on the rights of Indigenous peoples, they did that 3 years ago, and appointed Indigenous experts as its members. The expert mechanism is well placed to work within the wide range of, with the wide human rights network of the United Nations involving civil society. Now, both these structures I've mentioned have the opportunity to guide the United Nations in its actions and strategies to meet the needs of Indigenous communities. But these structures do not have a capacity to investigate abuses of human rights or to comment adversely upon the situation in any particular state. The Special Rapporteur on the Rights of Indigenous Peoples does, however, have a mandate to examine country situations and report to the Human Rights Council. And I'd point out here that James and I, the Special Rapporteur, did visit Australia in 2009 and has provided a report to the Human Rights Council. Australia is yet to respond to that report. The work of the Special Rapporteur can be closely related to the operations of the human rights treaty bodies. The following treaty bodies have mandates very relevant to the interests of Indigenous peoples and the rights contained in the Declaration. There's the Committee on the Elimination of Racial Discrimination, which looks after the International Convention on the Elimination of All Forms of Racial Discrimination. There's the Human Rights Committee, which looks after the Covenant on Civil and Political Rights. And there's the Committee on Economic, Social and Cultural Rights, which deals with the Covenant on Economic, Social and Cultural Rights. And of course, coming up, there's going to be soon a meeting on the Committee on the Rights of the Child, where they'll also be examining Australia's situation, including those of Indigenous children in this country. There is significant potential for the reports of the Special Rapporteur and these human rights treaty bodies to inform the international community and promote the implementation of the Declaration. As an example, the Committee on the Elimination of Racial Discrimination recently prepared a general comment on special measures which are taken by states because states are at risk of breaching the rights of Indigenous peoples through misunderstanding what constitutes a special measure in their legislation. And we see this example in Australia, particularly with the Northern Territory intervention. While the Special Rapporteur and the treaty bodies have the capacity to investigate complaints of human rights abuses, it is likely that their work will be more effective if they are able to engage states in a positive manner that can inform states of how to fulfil their international human rights obligations. It should be noted that the Special Rapporteur has a better opportunity to engage states in a positive dialogue. Unlike the treaty bodies, the Special Rapporteur does not need to wait for a 5-yearly report to engage with states, nor does he have formalised and complex procedures to receive or send communications on Indigenous issues. His interest can be invoked relatively simply by a letter, so Indigenous groups who feel that their rights are being threatened, who have exhausted domestic remedies to resolve the disputes, can request the Special Rapporteur to intervene or investigate. The Special Rapporteur has the ability to either visit a country to investigate complaints or to engage in correspondence with the states on matters of concern. Of course, his ability is limited by the attitude of the state and his capacity for the volume of work that is generated. Special Rapporteur presents his actions and findings in an annual report to the Human Rights Council, and he in fact presented that report on the 20th of September, just a week or two ago. 4 years ago, the United Nations implemented a new mechanism to ensure that states were meeting their human rights obligations under the UN Charter. The Human Rights Council now utilises a process called the Universal Periodic Review to examine all states and their human rights record in a cycle of every 4 years. And Australia appeared under that examination in January of this year and gave its response back in June of this year to that. And the response accepted most of the recommendations. There are a few key ones in there which people are disappointed they didn't accept. But it has obligated itself to now look to implement those recommendations through a National Human Rights Action Plan, which it's in the stages of negotiating at the moment, and also to report back to the UN not only in 4 years when it's obligated to report, but also in 2 years' time to give a mid-term update. For Indigenous peoples, it will be interesting to see if this new mechanism, the UPR, provides some teeth in the UN to hold states accountable for the situation of Indigenous communities and the enjoyment of human rights. It does not take much effort to understand that as Indigenous people seek to enjoy the rights contained in the Declaration, they will come into conflict with the states and other interests within the states. And in other interests, I'm referring particularly to economic forces, global economic forces that Indigenous peoples are finding. In Australia is a good example, but all places around the world, that they are still relatively helpless against the multinationals, the mining companies, that are trying to exploit their territories, and that states do little to intervene in that process. Rather, the policies of states is to promote that process as a form of development for the nation, but not necessarily the development of the Indigenous peoples. States will ultimately rely upon their sovereign status and territorial integrity to restrict international attention to disputes with Indigenous peoples. But Indigenous peoples can take heart in the United Nations position that the situation of Indigenous peoples is a matter of international concern. However, a positive result was achieved at the end of the preamble in the Declaration, where the text reads, "The General Assembly," quote, solemnly proclaims the following United Nations Declaration as a standard of achievement to be pursued in a spirit of partnership and mutual respect. The message of partnership is clear, directed more to states rather than Indigenous peoples. States are encouraged to act cognizant of the UN concerns for the human rights of Indigenous peoples with more initiatives to make change. The Declaration reminds states to comply with and effectively implement their obligations as they apply to Indigenous peoples under international instruments. But the first step is clear, and it should be a high priority for states. They must establish a partnership relationship with the Indigenous peoples for the purpose of establishing national and local plans and for addressing the capacity requirements within the populations, both Indigenous and non-Indigenous, to achieve these necessary changes. The states are all called upon to ratify International Labour Organisation Convention number 169, ILO Convention 169, which concerns Indigenous and tribal peoples in independent countries. It's an international treaty which also supports the rights of Indigenous peoples. So let me finish by saying a vision of the future. As each session of the working group on the draft declaration ended, we would travel home and be confronted with the reality of our people's daily tribulations, of the racism, of the helplessness, of the social dysfunctions and the indignities. Martin Luther King, in his famous speech, "I Had a Dream," spoke of going to the mountaintop and seeing the other side. He was declaring that he was able to see, to have a vision of what the future looked like in a different world and a different time. Many who worked on the Declaration on the Rights of Indigenous Peoples also had a dream. By analysing the text of the Declaration and musing on what this Declaration is about and being able to see and anticipate a better future, a real future, we can see the other side. We can see that Indigenous peoples of the world have established a new presence in global politics, capable of entering the domain of the states and challenging the oppression of the First Peoples. Self-determination, now established as a right of Indigenous peoples, is the future for Indigenous peoples of the world. Thank you very much.
Les, thank you very much for bringing us up to speed on where we are with the UN Declaration. Clearly there's a lot of work still to be done in the area of policy and action and programs and generally attitudes to Indigenous rights. I know Amnesty values your support, and this is an acknowledgement of all the work that you've done and that you are doing, and we look forward to collaborating with you in the future. Thank you for giving us your time today, Liz.